Good day, everyone, and welcome to today's webinar, All Climate Obligations, Erga Omnes. Further reflections on the ICJ's advisory opinion on the obligations of states in respect of climate change. My name is Conrad Cornelius, and I will be your moderator for today's session. This webinar is brought to you by the Climate Law and Policy team at the National University of Singapore Centre for International Law. To open the webinar, it is my pleasure to invite Ms. Danielle Yao, the lead of the Climate Law and Policy team, to deliver her opening remarks. Over to you, Danielle.
Thanks very much, Conrado, and a very warm welcome to our panelists today, Dr. Priya Ers and Dr. Craig Agate, and also to participants from around the world to today's roundtable discussion, right, our all international climate obligations Erga Omnes. While it has been just over a year from the issuance of the ICJ advisory opinion on the obligations of states in relation to climate change, the breadth, depth, and richness of the issues which the ICJ pronounced upon has continued to stir much reflections, both at the scholarly and the policy levels. More recently, on May the 30th this year, the UN General Assembly voted overwhelmingly 141 in favor, 8 against, 28 abstentions, in adopting a landmark resolution 80/263 that welcomed the advisory opinion. Among others, the resolution called upon all states to comply with their respective obligations under international law to ensure the protection of the climate systems and other parts of the environment from anthropogenic greenhouse gas emissions, and also noted the ICJ's finding that the breach by a state of any of the obligations identified by the court in relation to climate change constitutes an internationally wrongful act entailing the responsibility of that state. More importantly, the resolution effectively puts in place a pathway to operationalize the advisory opinion. Now, this provides really the perfect setting for today's discussions, which seeks to critically examine the advisory opinion with particular attention to whether and to what extent such obligations may be characterized as the Omnes. Let me take this opportunity now to express my thanks and appreciation to CIL's Conrado Cornelius, who has been really instrumental and been the driver really in conceptualizing and bringing today's roundtable to fruition. And it promises to be a very engaging and stimulating discussion, which I'm very much looking forward to. So thank you very much, and over to you, Conrado, to introduce our esteemed guest today and also to kick off the discussion. Thank you.
Thank you, Danielle, for those opening remarks. So to begin our discussion, allow me to briefly set out the background to today's webinar. So on 29 March 2023, the United Nations General Assembly requested an advisory opinion from the International Court of Justice on the obligations of states in respect of climate change, as well as the legal consequences arising from breaches of those obligations. The ICJ delivered its advisory opinion on 25 July 2025. The opinion was subsequently adopted by the General Assembly on 20 May 2026 by a vote of 141 in favor, 8 against, and 28 abstentions. The advisory opinion has been widely read as elevating certain climate obligations to obligations owed to the international community as a whole, in other words, obligations erga omnes. Today's webinar interrogates that reading. Which climate obligations, if any, carry erga omnes status and on what legal basis? How does this relate to erga omnes partes obligations under multilateral environmental treaties, to general international duties such as the no harm rule and due diligence, and to human rights obligations implicated by climate harms? Most importantly, what does all of these mean to state responsibility, standing, and remedies? To help us explore these questions, we are delighted to be joined online by two distinguished speakers, Dr. Priya Ers and Dr. Craig Agate. Let me briefly introduce them. Dr. Priya Ers is a junior research fellow in law at St. John's College, University of Oxford. She holds a PhD from University College London and an LLM from the University of Cambridge. Her current research examines the nature of states' obligations erga omnes and the scope for enforcing such obligations in international law. Her work in this field has been cited before the International Court of Justice in the case concerning the application of the Convention on the Prevention and Punishment of the Crime of Genocide between the Gambia versus Myanmar in the declaration of Judge Ad hoc Kress. Her article on this subject was awarded the inaugural ICLQ Hazel Fox Early Career Research Prize in 2025. Dr. Ers has also published extensively in international criminal law. Her monograph, Gravity at the International Criminal Court, Admissibility and Prosecutorial Discretion, was published by Oxford University Press in 2024. Her early article on this topic has also won the Journal of International Criminal Justice in 2020. Our second speaker, Dr. Craig Eggett, is an associate professor in public international law at Maastricht University, where he also serves as the program coordinator for the LLM in International Law program. He teaches public international law, international dispute settlement, and international institutional law at both undergraduate and graduate levels. His research focuses on the foundations of international law and the law and practice of the United Nations, with particular expertise in the sources of international law. Dr. Eggett is also a member of the Globalization and Law Network and the Maastricht Center for Human Rights. We are very pleased to have both speakers with us today. With that, let us begin the discussion. So there are 5 thematic questions. So the first will be on the conceptual foundations of Erga Omnes, the no harm rule and due diligence. Third, common concern, human rights and intergenerational equity. Fourth, treaty architecture and differentiation. And fifth, responsibility, standing, and remedies for Erga Omnes obligations. Now, the first question, I have 2 questions with me. So the first concerns, how do we distinguish Erga Omnes obligations from other obligations in international law? To be precise, what is the precise difference between Erga Omnes and Erga Omnes Partes in the climate context? Can a single climate duty be both? I now turn to Dr. Ers to share her thoughts on this question.
Thank you very much. And can I start also by thanking both Danielle and Conrado for inviting me to participate in this discussion on a very focused and important topic. So to start with, I should probably add a disclaimer, which is that I'm not a specialist in climate change or in international environmental law. And so I come at these issues from the perspective of general international law and how obligations Erga Omnes and Erga Omnes Partes are addressed generally. So in understanding what actually characterizes an obligation as an obligation Erga Omnes, it's quite helpful to look at the practice specifically of the ICJ, not only in the context of the climate change advisory opinion, but also more generally. And also, of course, the important work of the International Law Commission in its 2001 articles on state responsibility, where a lot of the consequences of this characterization have been addressed by the Commission. And so I think this is a subject on which I've written on. I think the difficulty that I have in identifying certain obligations as obligations Erga Omnes, whether in the climate context or otherwise, is that the practice doesn't actually suggest a very clear and consistent approach to this exercise. We do see repeated references to the existence of a collective interest of states, so a collective interest of the international community as a whole, so all states when it comes to obligations Erga Omnes, and a collective interest of a group of states when it comes to obligations Erga Omnes Partes. And typically, these are seen in multilateral treaties. But what I have noticed in some of the practice, especially of the ICJ, is that sometimes the ICJ has not considered the existence of a collective interest to be sufficient to establish the existence of such an obligation. So at times in the court's case law, we see references also to the importance of the rights underlying relevant obligations. So the idea is that the collective interest is justified by the existence of important rights that need to be protected. And a further approach that we sometimes see, more rarely in the practice of the ICJ, but certainly in a lot of the discussions of the ILC, was this idea that obligations Erga Omnes are obligations that are not capable of being bilateralized. So they're not performed bilaterally. And this often will imply that no other state is injured by a breach of such an obligation. And so the question of characterizing these obligations is tied very much to the question of who is able to actually enforce or not the obligation in question. And the rough difference that's often made between obligations Erga Omnes and Erga Omnes Partes, respectively, is that the former category exists under customary international law, And the latter category exists as a matter of treaty law, so within multilateral treaties. I'm not convinced that this is necessarily a formal distinction to be drawn, but certainly it is the distinction that we see in practice. But maybe I'll stop there for now and we can get into the details.
I now turn to Dr. Eggett. And any thoughts, especially on, well, picking up on Dr. Ursa's last remark, is the distinction between Erga Omnes Partes and Erga Omnes based on customary international law be fruitful? What are your thoughts?
I would start again also by thanking everyone exactly as Priya did, and also starting with exactly the same disclaimer. I am a general international lawyer, not an international environmental lawyer. So I think Priya and I approach this from the same perspective. On that last point, Conrado, to answer your question, that is, as Priya's mentioned, the main distinction between Erga Omnes and Erga Omnes Partes. I am also not necessarily convinced that that is due to the source of the obligation, but more the number of parties. So essentially, if it's for all states, then it is Erga Omnes. If it's for a limited number of states, that typically is under a multilateral treaty. But theoretically, I see no reason why that couldn't be under a regional custom, for example, because you have a limited number of parties that is Erga Omnes among those parties. But of course, practically speaking, we're going to be talking about the distinction between a general international law rule, typically referred to as custom, although I have some issues on the use and misuse of custom in many contexts here, and then Erga Omnes Partes within the treaty. And I would just say, of course, I fully agree, of course, with everything that Priya said before that. And I think this is, from the climate change opinion, and we'll get into lots of the detail about this, while the mere acknowledgement that some of these obligations may be Erga Omnes is of course very welcome, it is a bit of a shame that some of the details and clarification on these two distinct approaches that Priya outlined, whether it's the substantive importance of the rights or the structural nature of the obligations, there wasn't an opportunity or the opportunity was missed to clarify and really explain that. Even the individual judges, as I'm sure we'll talk about, only I think two of them in any real detail did add any on the question of Erga Omnes. So I think this is really while we have in scholarship the development of these, broadly speaking, two approaches, I think it is, despite something that we've been aware of and accepted for decades in international law, it's still something that is still surrounded by a lack of clarity.
Thank you so much for your answers. We can proceed now to my next question, and this concerns to the no harm rule and due diligence. So in the advisory opinion, the ICJ said some of the examples, although not exhaustive, but the no harm rule and due diligence are Erga Omnes. Now, I understand that you're both generalists in this sense, but perhaps I should also like to learn more some of your thoughts on, for example, does the prevention of significant transboundary environmental harm operate as an Erga Omnes obligation when the harm is global, cumulative, and probabilistic? I turn to Craig. What are your thoughts on this?
So if we take this sort of working model, that there's two main approaches, right? Like the substantive importance of the rights involved, and then the nature of the obligations as whether or not they're bilateralizable. I think when you're talking about this general duty, one of the main findings of the court, this generally applicable no harm rule, I think there's very good reason that this obligation could satisfy either of these, right? The substantive importance, the common good, the common interest that is protected, the importance of the climate system, the importance of the rights to any potential rights holders, and I'm sure we can get into that in more detail. That is something that does point in the direction of fulfilling that approach. And the same with whether or not these are bilateral obligations. Of course, it is possible, as it is with any sort of collective interest, some may argue, to conceive of it as a series of individual bilateral obligations, but of course that's generally not going to be the case. This is something that is considered, to transcend these individual interests of states, and the obligation is owed to the collective of the international community and humankind as a whole. So I think this core obligation, if it is one obligation, depending on how you distill that, I think does have the potential of fulfilling that. Now, again, the court in the main paragraph referred simply to this common interest, common good, I think was the phrase in 440, right? So, and didn't actually explain in any more detail how this would go. And did then also say that, following on from that, some obligations may. So acknowledgement that there is this common good, common interest, that and that might be necessary, and then that some obligations might be erga omnes as a result, but not saying exactly what else was required. So I think my short answer is yes, I do think that this could fulfill either of these mainstream approaches.
Yeah, I do agree with Dr. Eckert's assertion. Now, I was wondering, and then this I sent to Priya. Now, in the context of transboundary environmental harm, say in the context of climate, it's rather global, geographically, factually speaking. But yeah, there is no it is quite hard to really argue that unequivocally that climate protection is erga omnes, which is quite different, say, I think in your field, international criminal law, like genocide. Say, even when the impacts of genocide is not felt globally, it is nevertheless erga omnes. Could you somewhat draw some analogy or distinction? How are the different characteristics of climate obligations that are erga omnes with, say, other obligations in the context of international criminal law, humanitarian law, like genocide, is different and same at the same time?
Sure, yeah. And I think it comes back to the initial point about, what approach one actually takes to these things. And I think in the context of states' obligations in respect of genocide, so even putting aside kind of individual criminal responsibility, it might be easier to make an argument based on rights protection, even though the Genocide Convention itself doesn't actually confer rights on the groups that it is meant to protect. So, with that said, I think, that is sort of the logic that we do see in much of the discussion on obligations in relation to genocide. For me, I think the climate change advisory opinion is quite interesting when we talk about the obligation to prevent significant transboundary harm, because this would have been a very good opportunity to address the other approach, right? So what's often referred to as the structural approach. This is suggested by Christian Tams in his very good book on the subject. And I think specifically when we talk about protecting global commons, the structural approach makes sense because, as you said, it's not always easy to draw this line of attribution between a state's wrongful act and the harm or damage that is actually caused to another state. And so that sort of justificatory logic would have worked quite well to justify the status of the prohibition as erga omnes. And so for myself, it was quite surprising to see the court's advisory opinion limit itself to the common interests kind of framing of obligations erga omnes when justifying the status of the prohibition on significant transboundary harm. And maybe just to add as a little aside, so the Inter-American Court's advisory opinion on climate change in relation to human rights does actually also characterize the prohibition on significant transboundary harm as arising from a peremptory norm, which was quite interesting, and I think is also a distinction that we see between the two advisory opinions.
Thank you. I will now turn to another obligation also mentioned in the advisory opinion regarding due diligence. Now, this is a bit technical, but I think it's also very important. So the advisory opinion said due diligence is also erga omnes obligation. But how does it relate to how does the due diligence standard relate to mitigation, adaptation, and finance? How does the standard incorporate best available science and capabilities, and does that flexibility cut for or against erga omnes status? I turn to Dr. Priya for this question.
Yeah, it's a good question, and it's one with which I'm struggling a bit because I'm not sure how much the specificity of an obligation affects or not, if we put it that way, erga omnes status. I think if we look at obligations erga omnes partes arising from treaties, we might argue that even very specific obligations in relation to reporting requirements, for instance, for example, the Torture Convention can have erga omnes partes status. And at the same time, we also see much broader obligations that are not so specific being framed as obligations erga omnes or erga omnes partes. So yeah, I mean, I'm not sure. I think the problem of how due diligence is actually construed in the specific context of climate change is not one that is necessarily affected in any way when we have the discussion around erga omnes status. That would be my view. I'm curious to hear what Craig thinks, but yeah.
Yeah, over to you, Craig.
Yeah, I completely agree. I think that I understand the sort of trepidation when you see something that is maybe a sort of fuzzier standard to go, well, maybe let's be a bit cautious when assigning erga omnes status or whatever. But I don't think that should affect this status. So not necessarily going into the substance of due diligence as such, but whether we're talking about a norm like this, or whether we're talking about any of these climate rules in light of common but differentiated responsibilities, which I'm sure we'll get onto, that the individual content of an obligation varies across states and situations, I don't think affects the erga omnes status of that obligation. Again, it takes us back to the very beginning. And maybe before I go on to that, I should first say that, all rules, regardless of whether they have a list of factors, as in the due diligence obligation in the advisory opinion, or whether they seem very black and white, all rules have a degree of an open textured nature that require interpretation and that will apply differently in different circumstances. So this is an inherent aspect of law and legal reasoning. So the mere fact that we have a core obligation that in different circumstances might apply wildly differently to a developed state or a particularly active polluter doesn't necessarily affect that status. And I think it goes back to, as I said, to the initial point. We talked a little bit about the approaches to identifying erga omnes, but we didn't really mention the sort of rationale for erga omnes, and I think you could offer different rationales, but I think the core one is that it's essentially a tool for the enforcement of international law. It's something that, either because of the importance or because of the structural nature, requires some sort of additional procedural mechanism, granting a right of standing to all states or a certain group of states to invoke responsibility for violation of an obligation. So the content of that norm in a particular case and this rationale and the procedural mechanism that attaches to that rationale, I don't think necessarily impact one another.
Yeah, I mean, I have some thoughts also on this. I think one of the difficulties with framing due diligence as an erga omnes, even as an obligation itself, is because this is somewhat a positive obligation. There are things you have to do to fulfill this due diligence obligation. But then the question would be when can a state be said to have performed due diligence? It's quite different, say, for example, like genocide. As long as there is no massive killing, then the a state cannot be said to have violated genocide, something of that sort. I think the problem is, the challenge would be in the context of climate is what what are the things that states have to actually do to remain diligent? I don't know, just some thought from me. I now turn to a third question, and I think this relates to Craig's last remark. Now, if climate protection is a common concern of humankind, does that immediately imply erga omnes obligations, or is it just merely an interpretive context? What do you think, Craig?
So I think this, yeah, reference to something being a common concern, it serves different functions, right? So it serves a very basic rhetorical function. You're signifying as part of your reasoning the importance of the fact of the underlying values, interests, etc., that you're to which you're referring. But I think again, if you are referring, and again, it's important that we need to identify specific obligations, right? Because it is obligations that have this erga omnes status, and the fact that certain obligations are inspired and serve to protect common interests, I think could indeed then suggest erga omnes character. Again, to pick up from what Priya said at the beginning, it seems that maybe this is a necessary to have a common interest, but maybe not sufficient condition in order to develop erga omnes status. But I think it can both signify the importance of the norm and as Priya explained earlier, the nature of climate protection, the potential harm that could be done, and the interests that are served by obligations. I think point to this obligations that are not bilateralizable. It does, though, of course, also serve as this sort of interpretive to serve this interpretive function as well. But I think in terms of erga omnes, it could point in the direction of both, but it is not sufficient to merely in passing drop reference to a common interest and then all of a sudden you have an erga omnes obligation. I think you need to be a bit more precise in distilling these obligations, and I think that goes to your point that you made, Conrado, about genocide obligations. I think these are somewhat different, of course, and this, caution when we're talking about positive obligations is certainly something that I've seen in relation to the discussion on peremptory norms, use Kogan's norms, and of course you might simply argue you don't need to do that much of a thinking when you're talking about the negative obligation in relation to genocide because of its peremptory character automatically has erga omnes status. But I think regardless of what we're talking about, whether it's in whichever context, to distill these specific obligations out and say, okay, well, there's this general obligation, there's a positive, there's a negative, as we'll talk about later. I'm sure these very specific procedural obligations domestically, like distilling out each of these, and I looking at it as each specific obligation is very important to do in this context, particularly in the environmental context.
Over to you, Priya. What do you think?
Thank you. So I actually think in the advisory opinion, we sort of see the court using both approaches. And I have the paragraph here, so paragraph 440, where the court refers to the common interest of states in the protection of global environmental commons to justify erga omnes status in relation to certain obligations, but then also invokes the preamble of both the UNFCCC and the Paris Agreement, which refer to climate change as a common concern of humankind. And I think the court's kind of consistent approach in referring to the collective interest of states in compliance with certain obligations is easily met, in my view, when we refer to a common concern of humankind. Increasingly we recognize that states are not states just for the sake of it; they're states for people. And I think in the context of multilateral treaties as well, the court refers very often to the object and purpose of a treaty to conclude that certain obligations within it are erga omnes partes obligations. And so that is, in this context, again, what justifies what you referred to as kind of the interpretive approach or interpretive context. And so I think we see both. I mean, for me, I think the difficulty is that this sets a very low bar for establishing that certain obligations are obligations erga omnes or erga omnes partes, because in most multilateral contexts, so whether we're talking about customary international or multilateral treaties, it's quite easy to say that states have a common interest.
Before we ended off, we were talking about common concerns, human rights, intergenerational equity. Maybe let me just pause. Let me just move on to the next segment, which was on treaty architecture and differentiation. We can come back to the earlier segment so that Conrado can continue with that theme. Let me just try a segue now to treaty architecture and differentiation in the meantime. In the meantime, okay, so under the Paris Agreement and the UNFCCC, the obligations are often procedural and nationally determined. The question here is, can obligations of conduct which are framed through the NDCs and transparency, can they be considered erga omnes, or is it simply limited to a flaw of a minimum due diligence, which the ICJ spent quite a lot of time discussing? Priya, would you like to start off, and then we'll take it from there?
Sure, thank you, Daniel. So I think this sort of comes back to a theme that we briefly raised earlier. Craig mentioned it as well. So this idea that even sort of differentiated obligations where each state's obligation may be substantively different from another state's, the idea that these kinds of obligations could also be erga omnes partes within specific treaties. In principle, I don't see any difficulty with this, because all that the erga omnes status means, or all that it implies, is that the state owes the obligation to all the states party to the particular treaty. And so as long as, all the states party to the treaty are on board with that characterization, I don't really see the problem. So I think even in these kinds of obligations, of course, the justification needs to be met, right? So what is the justification for saying that these obligations are erga omnes? Is there a collective interest of states in compliance? What, all the different possibilities that we've already discussed. So I don't see a problem with it being differentiated, would be kind of my short answer.
Hi, can I jump in? Can you hear me now?
Yes, great. Go
All
ahead.
right, thank you.
Oh,
Yeah, some say our
Conrado, you're
colleagues
back.
have helped me. Yeah, thanks to some
No
of CL
problem.
friends helping me. So yeah,
No problem.
so sorry about that. Okay. Yeah, actually, I was still on question 3, but yeah, it's okay.
Can I suggest maybe, Craig, if you have any further response to that?
Yeah,
Maybe
sure,
we
sure.
finish, since we've just started this theme, we'll
Mhm.
finish this question, and then you can go back to complete the earlier set of questions under the third segment, and then we can continue from there. I'm very glad you're back online.
Yes, welcome back, Conrado. So, the first thing, I definitely agree with what Priya said. I think maybe 2 remarks here. The first is that while I completely agree that there's no reason why these kind of very precise obligations, technical procedural obligations, can't also be erga omnes, I think it would be quite a significant thing that such obligations were recognized as erga omnes, as typically when we see the list of uncontroversial, unequivocal erga omnes obligations, they typically are very similar to the list of uncontroversial Jus Cogens obligations. They are these very broad obligations, and I think identifying something really quite specific and technical as erga omnes would be noteworthy, I would say. And then I think one thing that is interesting, I think, in climate law in general, but particularly in this very specific context, is the relationship between these very specific procedural obligations and the overall obligation on the duty to protect the environment, right? So this is something that in the discussion of these individual procedural obligations and nationally determined contributions, the court itself even recognized that following from this general duty, there are these these duties to do things within the domestic context. And so even if we don't accept the erga omnes status of these specific procedural obligations, could the violation of these specific procedural obligations also violate the general erga omnes obligation? And how this would sort of interact with these things would interact with one another could potentially be very interesting. But I think when you are, within particularly such a general obligation, there are going to be lots of very specific procedural obligations that are packaged within that, right? And I think that's a very interesting question as to whether all these other obligations that serve to help you fulfill your general obligation also have the same erga omnes status. I think that's a very interesting, difficult question. I don't have a clear answer to. I wonder if it could be, well, maybe not every individual violation of the procedural obligations would amount to a violation of the overall general obligation. Would you need a violation of a certain kind? Would you need a sustained, systemic, repeated, a serious violation? But I think this is something that is to be maybe worked out by the international environmental lawyers and not for something for me to determine.
Over to Priya. I think Priya wants to say something.
Yeah, I just wanted to pick up on Craig's point because the court in the advisory opinion did say that it was only the main mitigation obligations in these treaties, so the UNFCCC and the Paris Agreement, that would have erga omnes status. It wasn't entirely clear on the point, but at one point at least the court did say that. And so on that view, then there would need to be some assessment of whether these particular obligations are in fact the main mitigation obligations, which again, I don't feel myself fully qualified to answer, but I would think so. But I guess it goes to the specific obligations again arising from the wider obligation. So just wanted to add that. Thank you.
No, that's very correct. And your last remarks relate very much to my next question. Now, in the climate context, environmental and climate context, there's this principle called common but differentiated responsibilities and respective capabilities. Initially, it was just different common but differentiated responsibilities, but now also with respective capabilities, meaning that well, although we still acknowledge that there are differences in capacities between developed and developing countries nevertheless should also do their utmost to mitigate climate change. Now, the question regarding to erga omnes would then be, does this differentiation individualize the content of a shared erga omnes duty? Who wants to take it first, Priya or Craig?
Briefly, I think I don't see the problem, and I think yes, it might individualize what different states actually are required to do. But the whole concept of erga omnes obligations is that there's a collective interest to be protected, and I don't really see the difficulty with saying that states have different burdens on them in actually protecting that collective interest, especially in the case of global commons, so common areas or common resources that are beyond states' individual jurisdictions. So I don't see the difficulty again with this idea. But again, I would be curious to know if specialists such as yourself, Conrado, might have a different view of that.
I don't have any views yet on this. I'm still also questioning about whether, well, intuitively, I do think so, but I mean, theoretically, in the abstract, yes, but how do you do that when it comes to like specific obligations? Say, in the context of due diligence, how do you differentiate the level of due diligence that developed countries should exercise and developing countries should also exercise? Is there like any difference in the due diligence between developed and developing countries? I also don't know that yet. So, over to Craig. What are your thoughts?
Yeah, I'd agree. I don't really see a difficulty at all here. I think, as I mentioned, it's a very similar answer to what I said in relation to the issue of scientific information and flexibility inherent in these rules. Again, with the application of all rules, certain principles or concepts operate in the background to aid their interpretation and determine the precise content in a specific scenario. I think, if anything, in the context of common but differentiated responsibilities and respective capabilities, you just happen to have in environmental law a bit more of a developed and precise principle in the background. It's actually a bit of a luxury to have and say, well, actually, we have this kind of thing operating in the background. The question of then which factors you would use to determine the specific content of a due diligence obligation or whatever, is one question, and determining the precise content and how it applies in different scenarios. But this erga omnes status, provided it, fulfills the underlying, rationale and the approach that you choose, in the absence of an authoritative, clear determination, I think that that's a wholly separate issue.
Thank you so much. It was a great answer. I'm now to my final set of questions, and this concerns responsibility, standing, and remedies, which I think is the creme de la creme, the crown jewel of the how to enforce erga omnes obligations. So the first is obviously, if certain climate obligations are erga omnes, who can invoke responsibility? Any state, regional organizations, or potentially non-state actors via domestic courts? I turn to Priya on this. I think this was related to your last CIL blog post somehow.
To some extent, yeah. So right, yeah, I think you're right in emphasizing this point, because the question of erga omnes status ultimately goes to the question of enforcement and standing. And so who has standing is assessed in different ways in international law, right? So state responsibility then feeding into questions of adjudication and jurisdiction before international courts and such. And I think it's important to mention first that, especially when we talk about multilateral treaties, treaties are capable of having their own rules on standing, and these would override any question of erga omnes status. And the ILC made clear as well that the rules on the invocation of state responsibility are kind of meant to be residual, right? So states can agree otherwise in multilateral treaties. So I think, to answer the question, the first place to look, especially when you're talking about a multilateral treaty, is simply the treaty. So far, a lot of the practice around erga omnes obligations and also erga omnes partes obligations has been interstate, in that it's the question of a state standing. To my knowledge, there hasn't been very much discussion of erga omnes status specifically kind of feeding into the standing of other possible entities, so whether international organizations or even standing before domestic courts. So I'm not quite sure if there have been developments in that direction, independent of specific treaties actually incorporating that sort of standing. So I don't think erga omnes status alone would necessarily translate to standing beyond states, as far as I can tell. So I'll stop there.
I turn to Craig. What are your thoughts?
So yeah, I would say it's certainly all states that can invoke this responsibility. The question of other actors, I agree. I don't think I've seen anything, clearly, pushing for this. I think a few things to maybe note. States frequently act through international organizations and regional organizations. So this invocation of responsibility might happen within a specific multilateral organizations forum, whether that is pushing for something in the General Assembly, whether that is states acting through regional organizations and trying to impose sanctions or issue statements or whatever. So I think that invocation of responsibility could happen through these international organizations. I think if you think more broadly that the international community as a whole is not simply a community of states, but is comprised of other actors, particularly certain international organizations, then maybe organizations could do that. But I think practically speaking, we're going to be talking about states taking the initiative here. I think it becomes a lot more controversial and difficult when we're talking about other non-state actors, whether this is NGOs or individuals or whatever else. And I think while these entities absolutely, as we've already seen, have a potentially very prominent role to play in the enforcement of climate obligations, I think they would usually do that within specific domestic contexts. And of course, some of our key cases come from exactly that. So I think that's probably more the role there. And there, of course, the international law in general, but also including the potentially erga omnes status, is not going to be determinative for standing within domestic systems by domestic non-state actors.
Right. Yeah, I would also like to add something. So I think, especially when it comes to erga omnes obligations, and this was first raised in Southwest Africa cases, the court does recognize the substantive nature of the obligation, but then refuse to grant standing to just like any states through a form of public interest litigation, actu popularis. The court simply says, and I think this was again reinforced by former ICJ Judge Gaya, saying the substantive nature of obligation is one thing, but the court's jurisdiction to grant standing to any state to enforce these erga omnes obligations are quite a different thing. Now, it also seems to me that in practice, seeing the recent practice of the ICJ seemed to be more welcoming to grant, say, standing to non-injured third-party states when it concerns erga omnes partes obligations, as we have seen in the Gambia versus Myanmar. But then when it comes to erga omnes obligations that arises from customary international law, I think the cases we have so far seems to be quite unsuccessful. I'm not sure why, but that's just how it is, I think, so far. And still related to this question, I was also wondering, what are your thoughts? So in the context of environmental law, there's this idea about intergenerational equity. So there are certain duties that is owed by the current generation to the next generation. Now, do intergenerational duties support an erga omnes framing? And can future generations be right holders for purposes of standing in families? Certainly, say, litigating before the ICJ is state versus state architecture, but can states base their say erga omnes argument on these intergenerational duties? Maybe Craig has an answer to this, a comment on this.
If I could maybe just make a comment in relation to your comment, Conrado, as well. I think it's just important to remember that the invocation of responsibility, that notion is broader than merely initiating proceedings at the ICJ, right? And when we're talking about, obviously, when we're talking about erga omnes partes, very frequently, as has been the case in some of the cases to which you referred, we have a complementary clause, and that, of course, is the jurisdictional basis. So I think one thing that is still something to be worked out, and I look to Priya to add to this because I think her article is probably the most extensive discussion of this question of standing before the court, is that you still need to satisfy the jurisdictional basis, and you still need to sort of reconcile that very broad non-injured state standing with the bilateral nature of disputes before the court, right? So I think this, in the absence of a treaty that contains a compromissory clause, this becomes a little bit of a thorny issue for the court to sort of deal with. So I just wanted to add a few comments on that. In relation to your questions about intergenerational equity, the sort of rights of future generations as well, I think this is obviously a very powerful and very true notion, device, concept to when you refer into these interests, rights, obligations, to underline the impact of the harm, to underline the importance of the obligations, to function as principles for the interpretation of these different rights and obligations. And I think, intergenerational equity, talking, really underlining how a specific obligation, whether it's due diligence or whatever these more specific obligations should apply, given the importance of the potential failure to do that is crucial. And I think, points in favor of both of the approaches to erga omnes. I would, though, say that I'm not wholly on board with the idea of a sort of rights holders approach to future generations. I think this is, while it could work, I think we're making our lives a lot more difficult if we're going to adopt a true sort of human rights-based approach to future generations, as rights holders, with questions of standing, with questions of harm and actual harm and things like that. While I would argue we probably already have the tools with the general climate obligations, with the human rights obligations to exist in generations, that maybe taking a sort of rights-based approach to that is quite difficult, I would say, and maybe raises lots of issues of harm and representation and things like that. While I'm fully sympathetic to the idea, and I think the human rights dimension of environmental harm is critical, I think maybe a sort of purely sort of human rights holders approach is a little we're making our lives a little more complicated.
Over to Priya.
Thank you. So I think it's quite interesting actually to think about future generations as rights holders, but I think we need to pause a little bit to think about what that actually means. And of course, we know from legal theory and philosophy that rights itself means very different things. And when I say, future generations could be rights holders, I mean in the sense of being the beneficiaries of the obligation, to use the ILC's language. And so I think it can be consistent with our current sort of framing to say future generations are the beneficiaries of certain climate change related obligations, but that the right to invoke responsibility for the breach of those obligations is vested in states. And I don't see any problem with separating those two things. So, what we might refer to as kind of like substantive rights holding, and then the right or the entitlement to invoke responsibility being different things. And it's completely acceptable, I think, for those things to be kind of given to different entities. What is quite interesting also is that this comes up in the question of reparations, right? So the ILC's approach in Article 48 was that even states other than injured states can seek reparation on behalf of either injured states or the beneficiaries of the obligation breached. I think it might be interesting and maybe a little bit of a creative exercise to think about what that reparation might look like when we speak specifically of future generations. It could, for example, mean something like, ensuring certain infrastructure is built to protect against certain effects of climate change, things like that. And I should say that was, of course, an exercise in progressive development by the ILC. And so in some of the current pending cases at the ICJ, we might have to wait to see what the court's approach is to this question of non-injured states seeking reparation for the beneficiaries of certain obligations. And yeah, of course, we'll need to see what happens in these ongoing cases and whether the court actually gets to that point of reparation. But it's nevertheless, I think, an interesting question to ask.
Could I just
Okay, sure,
add one
Craig.
very brief thing? So maybe I should explain my position a little bit more. So I do actually completely agree with what Priya said. I think this is a far more nuanced and sort of sophisticated use of viewing future generations as rights holders. Maybe more specifically, I'm a bit cautious. There's a few things I've sort of read and declarations of principles, etc., of future generations, is that this human rights approach is advocated to the exclusion of others. So what Priya's just explained is integrating the idea of future generations as beneficiaries of obligations and rights, and as those you're advocating for reparations on behalf, or you're conceptualizing harm in relation to future generations. This is integrated into the general framework that we're talking about. While sometimes I think this, focus on a human rights-based approach really is then essentially conducting a purely human rights exercise, which might work with an existing person who's suffered harm and is claiming rights before XYZ court. But I've read things that are advocating for that purely that in the context of future generations in various different fora, and I think that is what's making your life a lot more difficult, because you're having to engage in lots of these difficult philosophical questions and ignoring the existing framework, which is of course not what Priya did in integrating those. So I think it definitely serves a role to conceptualize future generations, but not to the exclusion of other norms.
Sorry, just to add, my agreement as well. So I should have clarified when I was speaking of rights, I wasn't speaking of all the implications of saying human rights, right? And that's what Craig addressed in his initial remarks as well. So just to clarify, yeah, I completely agree with the point about human rights framing having various other implications rather than just a kind of private law sort of rights understanding.
And I'm now down to my last question, and I understand we've had some questions in the Q&A box. I will address them after this question because some of these questions relate to some earlier questions we discussed in the beginning of this webinar. So, and last, but I think most importantly, is also the question of remedies. Now, in the context of climate, what are your thoughts about the forms of reparations that are plausible for diffuse climate injury, such as climate change? And are there, for example, any systemic collective remedies that are compatible with the law of state responsibility when multiple contributors cause indivisible harm? Who wants to go first? This is, I think it's a very tough question. Who wants to go first? I think Priya raised her hand just now.
I did not raise my hand.
Oh, all right.
But no, I'm happy to go first. It's a very big question, so maybe I'll try to address like bits of it and curious to hear what Craig thinks as well. I mean, of course, in principle, all forms of reparation could apply, but the specificities of climate change imply that some might be more realistic than others. So restitution, for instance, is unlikely to actually work given the irreversibility of the kind of harms we're speaking about. And compensation, I think, is much more realistic alongside perhaps some degree of satisfaction. But as you kind of hinted, Conrado, I think there are a lot of difficulties here. And for me, and probably for anyone actually working in climate change specifically, it comes down to the question of causation, right? So in actually attributing the harm to the wrongful act of a particular state. And so it is quite interesting, I think, to look at some of the discussions ongoing around how to address the question of causation, and what standards we might use beyond, the existence of this factual kind of causal link, which is very difficult in the context of climate change related harm. So I'm not very familiar myself with this idea of systemic collective remedies. So the way that I've kind of put it in my head is, well, negotiations leading to what we might then, call reparations, but where it's kind of a negotiated political solution, which, yeah, I'm not, familiar with the most recent developments on this in the climate change context, but I think that might be more realistic than actually, for example, adjudication to secure reparation for climate related harm. And I think this is also where the court in the advisory opinion didn't, in my view, go very far in addressing the very difficult question of causation. So it sort of just reiterated the standard that it has used in previous case law and saying, direct and well, I'm going to get the language wrong, but direct and, reasonably foreseeable harm, or please correct me on that. I'll need to look up the precise wording. But just to say that the court didn't really take its existing approach any further and said it's flexible enough to, to address climate change as well. So I suppose my response would be maybe this should just be a negotiated multilateral solution as states are trying to push for as well in certain contexts.
What are your thoughts, Craig?
Yeah, indeed. I think this is the key question, right? This builds on lots of the criticism of the advisory opinion. It's in lots of ways very welcome, but I think it was Judge Youssef, can't remember who was in the individual opinion, sort of describing this as a catalogue of the obligations, right, and not actually having any impact. So this is going to be the key question if there's going to be actual change as a result of this articulation of the law. I think on Priya's last point there, sort of negotiation and this kind of steps forward. I think practically that is what's going to have to happen, right? You're going to have this political will that meets, and then solutions are negotiated as a result. Now, what that reparation would look like is obviously an extremely difficult question. I'll look to Priya to see if she agrees with this, but I think I would say that the rules in our CEWA were developed with the kind of harm in mind that is very different to what we have here. These rules on reparation, typically we're talking about have bilateral obligations and harm in mind, and this kind of global catastrophic interrelated harm where issues of attribution, where issues of actually identifying harm and actually repairing that harm are extremely complex. And I think there's probably a need to sort of think creatively. I think if we're going to really try to, break down individual contributions and individual harm and quantify that, this is a very difficult exercise that's going to see lots of pushback. There's not something I know a huge amount about, but I am aware that there is I'll get the phrase correct, fund for responding to loss and damage. And sort of in a completely different field, I was reading about, in the context of space law, how to deal with the question of debris in space, and essentially this question of how do you determine whose tiny bit of debris came from whom and when and what kind of damage that might solve is deemed impossible. So instead, the idea is to sort of draw a line at a certain point in time and say, okay, everything before this line will sort of draw a line under. Any future potential harm is their obligations of mitigation and compensation, etc. And instead, it's on, in that case, spacefaring nations, but I would say in the context of environmental law, the biggest polluters, to contribute, and for other ways to generate these funds, to contribute to a sort of global fund that would then seek to remedy this damage. Because I think if we're going to try to apply these strict ideas of attribution and determining the degree of wrongfulness and the extent of wrongfulness and the harm, we are in for quite a mammoth task that I'm not sure anyone would really realistically want to do. And of course, this, from my understanding, this fund is at the moment not very well. I think there's a very small number of states, 25, 27, something like that have pledged funds, some very, very small amounts. This is nowhere near the amount that we would need to actually address this harm. So I think there's going to be a need for thinking of these kind of creative solutions. And I think anything that complies with the base general principle to try, the factory of Chozo rule to repair the harm, full reparation should be seen as compliant with the law of state responsibility, even if it doesn't fit nicely and neatly into one of the specific categories. But indeed, I think it's the killer question for sure.
Thank you so much, Craig and Priya. We've been discussing about an hour, and I know we have very limited time. So I will now turn to the Q&A. We have about 4 questions in the Q&A box. So the first question is from Ahmed Sabirin. Basically 2 things. What are your views about the legal criteria to be used to distinguish which climate obligations qualify as erga omnes and which one remain or should remain purely treaty-based obligations? And how, I think we did also discuss at great length about the next question, and he also asked the same thing. And how does the fulfillment of these erga omnes obligations be reconciled with differentiated obligations among developed and developing countries without undermining climate justice? What are your thoughts?
I could maybe go first. I'll take the
Sure.
first question, which I think Ahmed's question hints at a treaty-based obligation, so I'll address that context. I've written a bit about this, so it's about, in a multilateral treaty, which clearly has, a collective sort of purpose among the states parties. How do we differentiate which obligations are actually owed erga omnes partes from those which are not? And this is not a question that the ICJ has actually addressed, even while addressing erga omnes partes obligations in the Genocide Convention and the Convention Against Torture. So what I see, at least in scholarship, is broadly 2 approaches or 2 camps, which reflect the approaches also taken by the ICJ to the character of the obligation. So what I mean to say is there are some scholars who will say that if an obligation is closely linked to the object and purpose of a treaty, then it might qualify as erga omnes, while others would not. So there's some sort of question of how important, let's say, certain treaty-based obligations are for the fulfillment of the treaty's object and purpose. And you see Judge Ad Hoc Kress in his declaration in Gambia versus Myanmar, so in preliminary objection stage. He seems to hint at this approach as well. But then you have the other approach, which again returns to this idea of non-bilateralizable obligations, or the structural approach. So are there certain obligations which, if unfulfilled by a state, will simply not be enforceable if we don't recognize them as erga omnes partes? So lots of negatives in that sentence. But just to say that, it's the lack of enforcement that then justifies the character of the obligation as erga omnes partes. I think the first approach can be quite subjective, and this could be useful for the court in limiting which obligations are actually erga omnes partes, because of concerns about kind of, opening the floodgates to litigation and such. But the second approach, I think, in my view at least, has a certain appeal, because if erga omnes status is ultimately about ensuring the enforceability of certain obligations, then perhaps we do need to look at the question of whether breaches of certain obligations will never give rise to injury on the part of any state, and so then justifying enforcement by non-injured states. So I think I'll stop there. Curious to hear what Craig thinks.
Yeah, not much to add really. I agree with Priya's explanation. I think what's interesting is that I think while indeed the first sort of substantive importance approach is quite vague, somewhat quite subjective, right? Whilst the structural approach does have this at least on the face of it, a greater level of certainty and objectivity. I do think, though, that the structural approach will frequently entail satisfying the substantive importance approach, right? So if we think of situations and rules that exist whose violation won't necessarily result in an injured state that could be enforceable, it's generally then to protect a broader interest of the community as a whole, and that interest is substantively important, right? So I think the structural approach sometimes or frequently will also satisfy any interest-based approach. But I think that clarity, Priya's discussion of the identifying erga omnes partes obligations within the multilateral treaty, I think that logic to an extent could also be extrapolated to general international law, right? Like obviously within the context of a treaty, all the states have an interest in the performance of that treaty, but that doesn't necessarily mean that the interests are of such a nature that they're not merely a collection of bilateral, but they are collective. That's also true, you might argue, for the international legal system as a whole. The states as a whole have an interest in the performance of international law and respect for the rules in that system, but that doesn't necessarily mean that the rights are such that there's a collective interest of certain substantive importance of the rights involved. And so then, identifying what that extra threshold is very important. But I would, as I said, just largely agree with what Priya has explained there.
Thank you so much. I also would like to add, and perhaps this is a question, because in the last paragraph of the advisory opinion, the court did hint that the law itself might not be sufficient. So, and I quote verbatim: "A complete solution to this daunting and self-inflicted problems requires the contribution of all fields of human knowledge, whether law, science, economics, or any other." So I think other than just the existing legal doctrines, I think we could also consider gaining some insights from extra legal disciplines like economics. For example, in economics, it's been developed about common pool resources, but usually it's developed in the context of, say, natural resources in forestry, or in riparian waterways. But yeah, although the applicability of this approach in the context of climate, I do not think it's that developed yet, but it's been done in other disciplines. And I think to a certain extent, the framing of erga omnes obligations is not just a question of law, but also a question of fact. I'm just not sure that all kinds of common obligations, as contemplated in treaties or even in custom, can all be said erga omnes. I think we should also be looking at the factual circumstances of these obligations. Although I cannot really pinpoint which is which, but I do think the development of scholarship on this topic should very much consider the extra legal dimension of these obligations. Yeah, that's just a thought I have. Now, we also have another question. It's by Dominic Virgil. And she draws a comparison with the IDLOS advisory opinion. So in the IDLOS advisory opinion, the court offered an interesting perspective on stringent standard of due diligence, essentially pointing out that the efforts or measures taken by states should be aimed at reaching the temperature goal prescribed by climate change treaties. Do you think that this is a sufficient standard to elevate the obligation to Erga Omnes, so any climate obligations to Erga Omnes or Erga Omnes Parta status, simply relying on the climate temperature goal? What are your thoughts? Maybe I turn to Craig now.
Yeah, I think just essentially to echo something that I think we said a few times here. So the specific content of an obligation, in terms of the substantive standard of due diligence, whether stringent or otherwise, I don't think impacts this Erga Omnes character necessarily. I think again we just need to go back to understanding, depending on the approach or approaches or how you look at this, whether this is something that is this collective interest in the substantive importance of the right concerned, or whether it's non-bilateralizable. I don't necessarily see an issue there with that saying because a standard is particularly ambitious or protective or progressive or stringent or whatever, that speaks to the Erga Omnes character, if that's an answer to the question, if I've understood Dominic's question correctly there.
Yeah. So yeah, basically, how does the sorry again. Yeah. So yeah, this the temperature goal. Can the temperature goal serve as the determining basis to determine whether or not an obligation is Erga Omnes or Erga Omnes Parta status? Just relying on that. What do you think?
Yeah, no, I don't think so. No, I don't think that.
You don't think so?
I don't see anything specific about identifying a temperature goal that would, that would lead to determining the Erga Omnes character. Priya, do you?
So I think maybe just the fact of having a temperature goal. So, you might make the case that there's a collective interest in preventing global warming from exceeding a certain amount. So that on the ICJ's most kind of fundamental approach, we might say there's a collective interest in preventing global warming from exceeding a certain level, and that is reflected in the temperature goal. So I suppose, you could make that argument, but I agree with Craig that I don't think the stringency of the standard should make a difference. I think if you really wanted to make the case for it, you could say, well, the fact that there is a very stringent standard implies the importance of the collective kind of interest in preventing global warming and such. You could make the case for it. I think the problem is that the practice is vague enough that you could certainly make the case. But again, I agree that I'm not sure the stringency of the standard is what would be the strongest argument for Erga Omnes Parta status. Yeah, it's interesting. I mean, of course, in the ITLOS advisory opinion, the tribunal wasn't actually asked to address the legal consequences of breach. So you don't see, any reference to Erga Omnes in that opinion. But it is interesting. So the tribunal has in its 2011 advisory opinion, so on states' obligations in relation to the area, has made reference to certain obligations as being Erga Omnes. So it's not beyond the imagination of the UN Convention on the Law of the Sea, and obviously scholars have also written on Erga Omnes Parta's obligations in that context. So yeah, I guess we'll have to just wait and see.
All right. We still have some time for one or two short questions. So if the participants have any more questions, please do direct your questions to the chat box, to the Q&A chat box. Oh, okay. I have this question. So it's by Tariq Fayaz. I mean, his question is quite straightforward and simple. Could the advisory opinion be extended to private companies? I mean, I think he's trying to envision what state to a non-state actor dispute mechanism, something of that sort, maybe beyond the ICJ, because ICJ is state to state, but say other international courts and tribunals. Do you envision any potential for this?
Maybe just oh, sorry, Barry, do you want to go ahead? Maybe just to I think reiterate what I mentioned earlier. I think a particular flaw that we as international lawyers have is that we only really think about international law a lot of the time. And lots of these international obligations are going to be applied and enforced or influence the application and enforcement of law domestically. And I think that particularly when we're talking about private companies are central in the problem here, right? They're central in the pollution. That domestic proceedings are going to be central. So the findings of courts like the ICJ and ITLOS and the Inter-American Court of Human Rights frame the global standards that in turn influence how states' courts and states' legislatures frame the rules and apply the rules. So I think when we're talking about actions against private companies and the impact of things like the advisory opinion, it's going to be in that sort of indirect way that the advisory opinion will shape how states frame their laws, depending on the state, of course, how extensively they refer to international law. And then that will influence how they apply the law against private companies.
Priya?
Thank you. I'll answer the question in a slightly different way. I think in general, there's a lot of rhetorical kind of appeal of the concept of obligations being owed erga omnes to the international community as a whole, and that international community is not restricted, to states. And I think there is rhetorical value in that. But I also think from a legal point of view, we need to be quite careful about not invoking the concept for things that it doesn't actually support, right? So it comes back to this idea that obligations erga omnes are characterized as such because of the question of enforcement and standing. But we know that enforcement in international law is a very difficult question, and it's also multifaceted, right? So there are many different reasons why the enforcement of international law is particularly difficult. And the concept of erga omnes alone, which speaks to standing, can't resolve all of these other difficulties that still remain in terms of enforcement, right? So why is it difficult to seek enforcement against a private corporation? The answer to that question lies beyond, I think, in my view, the erga omnes discussion. Just as Craig said earlier as well, the question of satisfying a court's jurisdictional requirements is also relevant to the question of enforcement, but it's not answered by erga omnes status. Or certainly the erga omnes status of an obligation doesn't kind of override or itself satisfy these various other requirements for enforcement. I realize I'm answering the question in a very kind of broad way, but I think for me, this would kind of be the take-home message when we think about how widely we can kind of imagine erga omnes obligations.
Yeah, I very much agree with you. We also should be careful about how we frame how obligations are actually erga omnes obligations. It's not a, catchphrase to, just, this is erga omnes, this obligations are erga omnes, and then I can just sue any, I'm not injured, and then I can sue any state party. I think that brings us to the end of our discussion today. We've been talking for more than an hour. I thank you once again to Priya and Craig for kindly willing to share your expertise with us. In this webinar, and I hope we can have more webinars again with you in the future. And for the participants, thank you also for your kind attention. And keep a lookout at CIL website for future events, either on climate change or any other areas of international law. Thank you, everyone. Enjoy the rest of your evening or day, wherever you are. Thank you so much. Bye-bye.
Thanks, everyone.
Thank you.